regarding the very need of administrative discretion, we would like to discuss certain following factors such as modern welfare state. So, in a modern welfare state, the very objective is to achieve socio-economic justice. So, to achieve socio-economic justice, the very need is to take developmental activities in the field of health, education, food, shelter, communication, etc. So, the need of various new schemes and programs are being put into force by the state or the government. So, for the very purpose of socio-economic development and for socio-economic justice, which is the basic criteria of a modern welfare state, so for the very implementation, working and functioning of all the programs and schemes in the field of health, education, housing, food, etc., or in communication, the state needs certain discretionary powers, and such discretionary powers are handed over to the administrative authorities who, in the practical field, implement and work regarding their proper use and for effective functioning of those programs and schemes. So, for this, the state delegates certain discretionary power to administrative authorities. So, also, another need is that there is a lack of time for legislation, as the legislature is always busy in putting into the very effective functioning of the legislature by enacting essential laws, and those essential laws required definite constitutional and legislative procedures. So it takes times for the legislation of such essential legislations which relates to law and order, defense, foreign affairs, etc. So, due to that, the legislature has less time regarding all developmental activities and for that purpose, the legislature always enact the parent or enabling act, and it left those rules and regulations to be made by the administrative authorities through delegated legislation or subordinate legislation, and so that there is the need of discretionary powers in the hand of the administrative authorities. That's why, due to lack of time for legislation by the legislature, they delegate certain discretionary power to the administrative authorities. And the third one, the very technical nature of legislation. As we know, the very work of legislation involves technical and mechanical, so also scientific terminologies, such as, for example, any legislation, especially in the field of health, it needs The experts like those are the doctors, and regarding education, it needs those teachers, professors, and experts in education should also any legislation relating to the field of agriculture or in the field of science and technology. It needs the very experts in the field of agriculture like the agricultural scientists and those general scientists regarding the very legislation in the field of either health or education or in the field of agriculture or in the field of science and technology, and all these works involve technical terminologies and even certain legal terms are itself technical in their very meaning. So, for that purpose, as the legislators generally have little knowledge in the field of technical or mechanical or scientific terminology, so due to that they delegate or subdelegated certain discretionary powers in the hand of administrative authorities for the proper rule making or regulation making or regarding any notification or circular, etc. So another important need is for administrative discretion is flexibility, as the administrations they can either change or they can modify certain rules and regulation by their proper implementation, or if there is any shortcoming in any implementation of rules and regulation, they can change, they can alter or modify. Besides that also, there is a scope of experiment, and this provides that the administrative authorities, by implementing or executing certain discretionary rules or regulation, they can make an experiment whether such rules and regulations are being successful or effective. If they found they are not successful or effective, then they could make another experiment by making certain other discretionary powers such as new rules and regulation, and by their new experiment they can make their implementation, and also they can test their success and effectiveness in such experiment. And so also there is the scope of adjustment. So if any of the rules or regulations under the discretionary power of the administrators or administrative authorities, if there are certain inconvenience arises, then it could be adjusted by the administrative authorities, as it is a kind of discretionary power which is not possible in case of a legislation which was already enacted by the legislature. So also there are certain emergency, urgency, and contingencies, such as in case of natural disasters like earthquake, flood, then also during the time of war, etc. And in such urgency and emergency or contingency conditions or situation, it is the administrative authorities, by use of their discretionary power, they can control and handle such emergencies or urgencies such as natural disasters like earthquake, flood, cyclone, tsunami, landslide, etc. Also during the period of war, etc. So also another very situation, that is the regional and local needs and demands. So as the very state is a vast area and comprising different linguistic, religious groups, so the local or regional needs and demands differs from one region, one locality to other, and in such situation it is not possible to legislate in the legislature specifically for those regional and local needs and demands, and in such situation the administrative authorities or the administrators, by use of their discretionary power, they could meet the very regional and local needs and demands. So these are the factors which makes the very necessity or need of administrative discretion or administrative discretionary power to be used by administrative authorities to meet such urgency, emergency, or contingencies, also to meet regional and local needs and demands of the regions and localities. And as already we have discussed regarding the factors of modern welfare state, then lack of time for legislation, technical nature of the legislation. So this is the very reasons or factors that are necessitated for administrative discretion.